Good afternoon, everyone. Welcome to our monthly webinar. This month, we've got a bit of a treat for you. We're joined by Jessica Farthing, who's a partner at Grant Thornton Australia. And so today we're going to be talking to you about annual salaries, what they are, how we might be able to assess compliance as against awards, and then some practice tips in terms of how you might start to look at calculating annual salaries, considering how the Fair Work Commission or Ombudsman might look at it, and then also talking about if we get it wrong, what might be some outcomes of that and how we can navigate that. So in terms of what we're going to go through today, we've got quite a good lineup of discussion topics. So first of all, I'm going to touch on award coverage and award classification, because that's really the starting point of assessing annual salaries as against awards. And just to confirm, for today, we're only focusing on award covered employees. And we're focusing on that because of the annual salary provisions in awards. And also that tends to be where people come unstuck in terms of providing annual salaries to employees and then perhaps not meeting the requirements under the award. And then I'm going to hand over to Jessica, who will talk through a tool that they've got that helps assess compliance really at a base level, and then how they can work with you beyond that. They've got a variety of ways that they can work. And really today's a discussion about how Jessica and I work together in terms of you've got your lawyers and your accountants, and unfortunately neither of us can do it all. I'm sure data analysts. I became a lawyer because I don't want to have to deal with numbers too much, and probably Jessica would say the same. I think she became an analyst because she doesn't want to have to write too much. Yeah, it's really how we work together and how you might work with your service providers in terms of making sure that you're compliant. And then I'm going to talk about the difference between an annualized salary clause in the award and just a general set-off clause, and I'll talk about the distinction between the two of those. We'll both touch on some record-keeping obligations, and then I'm going to just touch on how the Fair Work Ombudsman might look at things. For those of you who don't know me, I know that we've got a mixture of clients here today. So I'm Erin, I'm a partner at the firm called Vincent Young. I head up the employment and workplace relations team. I've been doing employment law for over 13 years now, and this is kind of our bread and butter work in terms of award compliance, award coverage, those types of things. And obviously we assist clients across the whole life cycle of employment, everything from recruitment, induction, employment contracts, policies, right through to termination of employment and post-employment restraints, enforcing things like that. So I'm going to hand over to Jessica now, who will introduce herself.
Thanks, Erin. Hi, everyone. I'm Jess Farthing. I'm a partner at Grant Thornton. I lead our data transformation analytics team. So as you can tell probably from my accent, I am American, and I started my career in traditional tax, but really had a data-heavy kind of approach to everything that we were doing when I started my career 15 years ago. So it gave me great opportunity to come out to Grant Thornton Australia, launch analytics for the firm, but equally anything that involves setting some business rules and throwing some data against it to validate outcomes is really kind of the specialty. I lead a team of data specialists that, with a distinct focus on payroll and workforce type issues. So we, keep abreast of the hot topics, what's going on, and with a view of designing bespoke tools, but also obviously undertaking kind of those long historical calculations that I know most clients find themselves needing to do after maybe some risk is identified. But happy to be here to talk to you today a little bit from the accounting point of view as to what we get asked in our approach to these reviews.
Thanks, Jess. And you'll probably see Jess and I tag team in terms of points we might raise when each other is talking, just to kind of talk about how they, as I said, both kind of services will intersect. And I think Jess and I have talked about how a client might come to Jess and say we would like to undertake an audit to assess our employees against annual salaries and awards and things like that. And kind of the first threshold issue that we need to ask ourselves is, okay, well, one, are these employees award covered? And then two, what classification do they fall into under any relevant award once we've assessed, yes, that they are covered. And so that's something that generally an employment lawyer would assist with. Correct me if I'm wrong, Jessica, but I don't think you might make some assumptions around classifications or award coverage, but really I think any accountant would be referring you to an employment lawyer to really understand award coverage and award classification. So I thought I'd just touch on that first of all, so really as a baseline of kind of where we start. And there's always, I give webinars all the time where I talk about this misconception, sometimes in the market, not so much probably with HR, but others, I think, that say, oh, we pay above the award, therefore employees aren't covered by the award. And that's technically not correct. So if there's an award that covers an employee and they fit within the classifications of that award, then the award will apply to them. And we need to make sure that whatever salary we're paying, if you're choosing to pay an annual salary to that employee, that they're getting paid adequately when compared against the award. So just because the award says the base salary is 55,000 or something like that, and we're paying 70,000, for example, that doesn't mean we don't have to worry about the award anymore. The award still sets those minimum terms and conditions of employment. So we need to be very much across award coverage in our organisation. And in terms of awards, we've got about 130 of them now. We started in 2010 with about 122, and we've kind of built on those in terms of getting a few different ones. And we've the Commission just finished a review of most of those awards. So for those of you who are in HR, you probably will have seen a change, and most awards now refer to a 2020 award rather than a 2010 award. And that's because we saw some changes and updates to awards in 2020 and last year to reflect changes in terms of the workforce and specific industries. And so what you'll find in awards is that we have occupation-based awards and industry-based awards. So an industry-based award, for example, would be the General Retail Industry Award. So that covers an industry-specific organisation. And I've got an example on the next slide around coverage clauses in awards. And then you might have an occupation-based award. So, for example, an occupation-based award that applies to a lot of organisations is the Clerks Private Sector Award. That covers a lot of administrative employees in your organisation. And so what we need to do is assess which award applies. And you could have a number of awards that apply to your organisation. So just because one award applies doesn't mean all of the others don't. You could have a number of awards that apply. So for example, if an industry-based award didn't have classifications for clerical employees, then you would look to the Clerks Private Sector Award to cover your administrative type employees. So for example, just say you're in the manufacturing industry and it didn't have any classifications for your office-based staff who might do payroll or accounts or things like that, then you might also have coverage under that occupational-based award for your administrative employees. So we really need to be looking at those coverage clauses in awards, and I've got two examples in a second, and making sure that we're comfortable with the coverage under those clauses and we think we fit into those awards. And then it really comes down to the employee and what duties they are performing. And the Commission will apply a test of, okay, is the employee classified within an award? What's the principal purpose of their employment? And they'll classify them under an award based on the principal purpose of their employment. And so that's why an employee's duties and responsibilities are very important to make sure that we've got them clear so that we can use a job description or something like that to assess an employee against the award classifications. because the award classifications are very descriptive. If you go into most awards, they'll have probably 5 or 6, maybe 10 sometimes different classifications, and they'll generally have indicative job duties and requirements. And so what you can do is assess your job description that you've got for a particular role against those duties in the award classifications, and you should be able to marry up one against the other. So as I said, I've got 2 examples here of an industry-based award and an occupational-based award. So just here, I've got the General Retail Industry Award. And you can see that it's very specific in terms of it defines what general retail is. So it says the retail sale or a hire of goods or services for personal, household or business consumption, and then it kind of gives you a list of what those things would be. But then it also is very specific to say, but it doesn't cover these things. For example, pharmacies, hair and beauty establishments, nurseries, butcher shops, manufacturing, things like that. And that's because there's specific awards that apply to those industries. And what you will generally find in most awards is that clause 4 of the award will be your coverage clause. So I would encourage you to go to that clause first if you're assessing award compliance, and that's what we do if we're instructed. So we do a lot of projects looking at award compliance, obviously. We go to that clause first, understand what the client does, and then look at that clause and the exceptions in that clause to determine the award coverage. And then the other one, this occupational-based award, you can see again, clause 4 is talking about the coverage. And you can see there it says it covers employers throughout Australia in relation to their employees who are wholly or principally engaged in clerical work. And again, it says in 4.3, a bit further down on the screen, it says it doesn't cover employers who are covered by a modern award that contains clerical classifications. So if your occupation-based award has clerical classifications, then you don't need to look at this award. It would only be if that award doesn't have coverage for clerical type admin roles that you would look to this award. So again, you get very good guidance from the awards themselves in terms of coverage and classifications. And so again, I would encourage you to, first of all, assess award coverage and don't just assume because we pay above the award that the award doesn't apply. We need to be looking first. I would start with your industry-based awards and assess what industry would fall in, and then look to see if there's any other occupation awards that might apply to us. And you can find a copy of list of the whole of the awards at the Fair Work Commission website. They've just got an alphabetical list. So that really gives us the groundwork for assessing coverage under an award. And now I'm going to hand over to Jessica, who's going to talk us through a tool. So once we've established, yes, we've got award coverage, and we're trying to look at, okay, does the salary that we pay an employee compensate them for their entitlements under the award? How do we go about doing that? So I'm going to hand over to Jessica now, who's going to talk us through that.
All right, thanks, Erin. I might just click through.
You should have, I've given you control.
Yeah, so I might just click through to the next slide. So, just to start off, as Grant Thornton, we're a full service public accounting firm. And clients kind of approach us with a request for services across a multitude of ways. So we've kind of come up with this continuum over the past, I would say, 4 years of what clients actually ask us for, where they're at in the process of an internal review or having identified issues with payments to employees. And ultimately what we've come up with is there's 2 buckets that basically our clients or contacts kind of fall into. The first one being that they want to know if the organization's at risk of not being compliant with award rules or payment criteria to the employees. And they've not really diagnosed that yet. So they're looking for the health check, kind of a confirmation of key risk issues that might actually be there within the organization that would require a deeper assessment or actual calculation of pay to verify if there's been any shortfall. Secondly, or they've already engaged an employment lawyer, kind of gone through classifications and award coverage, they've come up to maybe approach us on the back of that saying, we had employees that were misclassified. Can you undertake a payroll recalculation of X number of employees? And where there's a shortfall, we intend to make back payments to employees. From payroll recalculation onwards on the continuum, that's really kind of in our remediation bucket because the problem and the likelihood of risk has already been diagnosed. So, sometimes that we don't have an opportunity to ask a lot of detail about, the details that we need to kind of really frame up the scope and the level of assistance and efforts that's required on our end from an accounting firm. And I find that it's really helpful to basically kind of give insights into how you might be paying your employees at a basic level, and that fosters a lot more support for where deeper efforts are actually used and concentrated in the course of any additional reviews or in the course of calculations only being needed for the right cohorts involved. So I thought it would be good to kind of just show you an analytical tool that we've created with the purpose of, letting scenario testing what could be work patterns by your employees, and since checking if the salaries that have been paid for them are sufficient as just kind of a baseline measure. And from there, I find that it really helps, generate additional questions and knowledge about your contractual terms, coverage, all the little details that kind of fold into doing a exact calculation in a way that's, I think, worth everybody's time. So what I might do is I will stop sharing there and share my screen. And let me know if that screen share has come through.
Yes.
Okay, great. So I'm conscious the font is a little bit small, but what I wanted to walk you through is kind of the analytical app that we created to get meaningful discussions rolling where up front we might not get all the detail in how the review is, what's going on in the background prior to being requested to do a deeper review from Grant Thornton. So what we've done is we've printed a way to enter various working scenarios that are going to test, how this, that are going to arrive at estimated salary values and really kind of short test maybe where the annualized salaries of your employees kind of fall within, a baseline analysis. So, for the purposes of, we have a lot of content, a lot of rate tables for different awards, from previous engagements that we try to repurpose into building meaningful tools. So first and foremost, selection of the award that you think might apply to your employees, maybe disclose annual leave, but it gives you the opportunity, so this tool here gives you the opportunity to kind of, just paint different work patterns that you might want tested. So for scenario 2, a default is scenario 1, that's just testing if an employee is working 38 hours a week, all within the span of ordinary hours. It'll spit out a calculation of expected salary point for the award that was selected and their level that's been mapped in. So in scenario 2, maybe I'll enter that an employee works 40 hours a week and it's asking, are they likely to work on a public holiday? I might say no. Are they likely to work on a Saturday? No. How about a Sunday? No. So asking about public holiday weekend time to really kind of test those penalty conditions. For this next scenario, I might want to plug in that they work, let's test 43 hours a week, something above the normal 38. But no public holidays are expected, no weekend work's expected. The next one, let's test how an employee works 38 hours a week, but they are likely to work most public holidays, maybe a lot of Saturday and Sunday time, just to see how those penalty entitlements really kind of fare against the salary point. And the last one that I'll plug in here for demonstration purposes, going back to, let's say on average, they work 43 hours a week, and they do actually work, public holidays, Saturday, Sunday. For this job role, that might be likely. So when I push finish here, what it does is it runs in the background and kind of spits out an analysis. And I might minimize my viewing screen if I can. So what it's done is it's processed 104 employees, and against scenarios 1, 2, 3, 4, and 5 that you just saw me plug in, you can see that it says, okay, well, 99 employees breached, didn't have sufficient salaries, but at what point, at what scenario did they actually breach? You know, it kind of is a bit of a mix here. 5 employees actually had sufficient salaries even against the most robust scenario, which would have been the scenario 5, which is 43 hours a week, a bit over 38 hours a week, but working all public holidays and weekend time, you know, that would be likely. So you can see for these employees, the salary, you know, range was actually there's a big spread. There was one employee who, when measured against working 38 hours a week, all within the span of ordinary hours against the minimum rates of this award, and it's really kind of fed back that employee's salary should have been $47,000, but he was only on, you know, $40,000. Therefore, there's kind of an immediate investigation that, you know, somebody would be likely to want to perform as to, you know, why the salary point might not be sufficient against the award criteria. Going to the others, you can see that for scenario 3, which is working 43 hours a week, but no public holidays or weekend time is expected. There are 33 employees at risk of salaries not being sufficient. The largest one is about $6,000, all the way down to somebody who is only short $14. But when you kind of drill down, you can actually kind of understand what the salary reports are against the scenario. So very likely somebody on $51,000 a year in the role. If scenario 1 was estimated at 47, scenario 2 at 50, you can see how the buffer is big enough to cover those working scenarios. But by the time you consider if they worked 43 hours a week, despite not working on weekends or public holidays, you know, we might run a risk of them, you know, actually being at risk of their salaries not being sufficient. So I find that these are the types of tools and assessments that, you know, we try to come up with so that we get more concentrated responses from the organization about deeper dives, you know, all the details that flow into the next stage of calculation being as accurate as possible. That I feel like that this kind of makes everybody actually kind of think about the working conditions of their employees against, you know, the expected work patterns. So I might stop sharing on that one and toss it back to Erin after that demonstration.
Thanks, Jess. Yeah, so I think that tool that Jess just shared with us is a really good example of the way that we can start to assess award compliance against the annual salary clauses. So if you think about, okay, like in that example that Jessica was talking about, we pay an employee $45,000, what assumptions can we make to assess kind of where we're at in terms of award compliance? So are we very certain that all our employees only work 38 hours a week and they don't do any overtime, and there's no penalty rates that apply because they don't work on Saturdays or Sundays or anything like that? And you can very quickly see using that tool whether we're okay or not. And then you can make some different assumptions, because I think most of us probably would be able to acknowledge that not every single employee in our organisation probably is working a strict 38-hour week, full-time employees I'm talking about. So then, okay, what factors are we going to build in to those hours of work? So is it reasonable to say, for example, employees might do a couple of hours extra a week? And technically under the awards, what that means generally is that anything over the 38 hours a week or outside the ordinary span of hours would attract an overtime rate. And so that increases the hourly rate that an employee would be entitled to. So we need to be sure that the salary that we're paying employees compensates them for those 2 additional hours each week that they might be working. So I think it's a really good baseline to start. And then obviously as an organisation, you can ask more questions. So Jess can say, okay, here's kind of the baseline. And then you say, well, actually, they're not working 2 hours every week. It might be, you know, once a month or something like that. And then you can drill down further. And that really, I think, talks to the point of record keeping obligations and making sure you've got appropriate records that you can pull on to kind of do this assessment, and also from a compliance point of view, which Jess and I will talk about a bit later. Jess, did you want to add something?
Yeah, I think I just was going to piggyback on that comment as to, you know, where we generally go to it is we can either kind of customize further and, you know, the assessment, rerun it as you would have saw with pretty efficiently, pretty easily for very low cost. Or what might come to the surface is everybody recalls special arrangements that maybe certain employees might have with the employer that deems it, you know, working outside of roster hours may happen, but you know, they kind of actually know their workforce and their business better than anybody. So I think it's helpful for everybody else to kind of participate and connect the dots as to you know, what's disproven and maybe the core assumptions, but sometimes that actually might warrant calling back your employment lawyer, you know, for deeper contract, you know, dives and considerations, or undertaking those efforts, you know, internally, because I think it might generate where, you know, we next move on to actually just testing the actual time worked rather than assume scenarios to see how it plays out against the diagnostic. Or there might be more of like a coverage documentation type support that rises to the surface, but it's really helpful that, you know, it just pins down the right efforts, I think, want to go forward, that manages, I think, costs and everybody's time further down the road.
Yeah, and clients come to me and say, well, where do I start in terms of calculating the annual salaries? And I think those assumptions that you're talking about in terms of, okay, well, let's just start on the assumption that everyone's working 38 hours a week. And then, okay, does that raise any red flags for us? And if you did that example there, then it would raise a red flag for that one employee. And then, okay, what other assumptions might we make? Are they working 2 hours a week? And so I think it's a really good starting point to kind of look at, okay, is what we're paying enough to compensate them for those award entitlements? Or do we have to look a bit further and do, as you said, that deep dive into certain arrangements? And so one thing that I wanted to talk about, which sometimes gets a bit confusing, and hopefully I can articulate it in terms of the distinction so you're not so confused, is that there's kind of two different ways that employers in my experience will pay employees. And so one is under an annualized salary clause in modern awards. So a lot of modern awards will have a specific clause called an annualized salary clause or provision. And what that is, it's a very specific clause that tells us how we can pay an annualized salary to an employee. And it also tells us the provisions of the award that we can kind of include in that annual salary. And we'll look at an example again in the Clerk's Award in a second around what that clause actually looks like. And so what that allows an employer to do is annualize that salary over a 12-month period to pay all of the entitlements basically under the award. And so at the end of that 12-month period, you would do an assessment to say, okay, have we, based on what the employee has worked, have we adequately compensated them? If the answer is yes, then there's nothing you need to do. If the answer is no, then you need to make up that shortfall. But with these annualized salary clauses in a modern award, they are very specific in terms of what you need to include in a contractual clause or when you give an employee that annualized wage arrangement. So you need to kind of come up with outer limits of ordinary hours that will attract a penalty rate. And it's very, very kind of administratively heavy in terms of assessing that annual salary. And you need to, again, if an employee works outside of the kind of hours that you've articulated in your calculation in a particular pay period, so if you pay fortnightly or monthly, if they work outside of those hours, then you need to pay them or top them up for those additional hours in that pay period. So that annualized salary clause provision is very specific. In contrast to that, what a lot of employers do, which doesn't have that administrative burden so much, is use a contractual set off clause. So you might see a clause in a contract that says, we'll pay you an annual salary of $75,000, and that compensates you for all your entitlements under the award, including loading, allowances, overtime, etc. And you kind of set off the amount that you're paying that employee against those award entitlements. So there's two different ways you can do it. And even if your modern award has an annualized salary provision, you can still use a contractual set off clause. So there's no requirement for you to only use an annualized salary clause if there's one in the award. You can do that contractual set off clause. But with the contractual set off clause, we don't have the luxury of coming to the end of 12 months and saying, okay, is what we've paid the employee satisfactory to compensate them for all of their entitlements under the award for that whole year? What we need to be certain of if we're using a contractual set off clause is that each pay period that we pay an employee, so each month or each fortnight, that what they would have received under the award, they're adequately being paid that in terms of what we're paying them. So if we're paying them $2,000 a week, that they would have received something less than $2,000 a week under the award for that pay period. So we don't have the luxury of kind of ebbs and flows across a year where you might work less hours on one week and more hours on another. We have to be certain that in each pay period, what we're paying an employee compensates them for their entitlements under the award. So that's really the difference, and also all of the administrative requirements that we'll look at in a second, in terms of that contractual set off clause and an annualized wage arrangement under the award. And so these annualized wage arrangements, you've probably heard, it was last year or the year before where we kind of saw a change to how these work in practice. A lot of employers haven't actually adopted the annualized wage arrangement under the award because of the administration that's involved in looking at those and setting the outer limits and those types of things.
Yeah, and I might just quickly mention is that whenever I demoed the tool, I was showing the assessment at an annual level as compared to their annualized salary amount. But we've actually gotten more granular than that to where we can do the diagnostic at a fortnightly level or a monthly level in accordance with, maybe the exact pay period frequency, so that, that can be used as, ammunition, I suppose, to say, well, of course, they might not be underpaid at an annualized basis. However, if they're getting paid fortnightly, but they had 4 payroll periods that actually had shortfalls within those payroll periods, you can actually iron out in a lot deeper detail which of the provisions, would be agreeable, and how to recognize the actual shortfall from a legal perspective.
And I think that's helpful, again, if we're using a contractual set-off clause to identify, oh, okay, well, when we look at that on that very granular level, on a weekly level or a monthly level, we aren't compensating them in some months or weeks adequately. So we might have to top up that annual salary a little bit so that, it kind of evens out across the year, to make sure that we're compensating them in each pay period for the hours that they would have worked. And so, as I mentioned, the record keeping obligations are quite specific in terms of the annualized wage arrangements under a modern award. And also if we're just using that contractual set off clause, and I'll touch on that a bit later on. But what we need to be sure is that this annual wage is sufficient to cover their entitlements in each pay period under a modern award if we're using that contractual set off clause. So to give you an example of what the annualized wage clause will look like in an award, I've taken the Clerks Private Sector Award as an example. So you can see here that it says an employer can pay a full-time employee an annualized wage. And so that's very specific. So a part-time employee can't be paid an annualized wage arrangement under this clause. Yes, you can have your contractual set-off clause for a part-time employee, but under the award, only full-time employees are entitled, can have these annualized wage provisions. And you can see there, it then has a very extensive list of what is covered in that annualised wage arrangement. So it covers minimum rates, allowances, overtime, time in lieu, shift work, annual leave loading. So a lot of awards have a 17.5% leave loading, all of those things. So you can kind of say, okay, our wage arrangement satisfies all of these obligations. And that means that we really don't have to worry about any additional payments under the award in terms of overtime allowances, penalty rates, things like that. But you can see here, as I said, it's very specific in terms of what you need to do if you're going to choose to use this arrangement. So you can see it says where an annualised wage is paid, we need to advise the employee in writing and keep a record of the annual wage that we're paying, which provisions of the award we're saying is satisfied by that wage arrangement, how we've calculated the annual wage, including each of the components and any overtime or penalty assumptions that we've made. So if we've assumed they're going to do 5 overtime hours a week, we need to be specific around that, and that they're going to work a Saturday and that attracts a penalty rate. We need to be specific about that. And then also the outer limit of the number of ordinary hours which attract the penalty rate and the number of overtime hours. So we need to kind of have a maximum. So we say the annualised wage arrangement compensates for a maximum of 10 hours overtime a week or something like that. And then outside of that, they are paid in excess of the annualised wage arrangement. And you can see there, so that's very specific in terms of a lot of things we need to cover off if we're going to choose to use this annualised wage arrangement under the award. And then, as I said, if in any pay period or roster cycle, they work in excess of those kind of limits that we've set, then they need to be paid on top of their annual wage for those outer limit hours. And you can see here that they have to obviously not be getting less than what they would have received had they performed the work under the award for the whole year. And if their employment comes to an end during that year, then whatever that period is. And as I mentioned, each 12 months, you kind of, as an employer, need to sit down and do a calculation and make sure that what we've paid them is sufficient to what they would have received under the award. And again, you can see that C on the screen there is saying that we need to keep a record of the start and finish times of any work that's performed, any unpaid breaks that they take, in terms of employees that are subject to this annualised wage arrangement. And that record needs to be signed by the employee or acknowledged as correct in writing. So that's why I was talking about it's very administratively heavy in terms of adopting this arrangement, which is why we don't see a lot of employers use this. And really what you'll generally see is that contractual set off clause, where it says we're paying you this amount to compensate you for all of your entitlements under the award. And that's why I'm saying you really need to be certain. And I think that's where a tool like Jess's is really handy to say, okay, when we break it down, are we satisfied that on the assumptions that we're making, employees in each pay period, we're adequately paying them for what they would have received under the award? And we can't have this kind of ebb and flow arrangement. We need to be certain that each pay period they're being satisfied in terms of their minimum entitlements under the award. So the other things that I just wanted to touch on before I hand back over to Jess is that obviously we need to be familiar with the terms of our awards to make sure that we're compliant. Also remember that generally on the first pay period on or after the 1st of July, wages increase under modern awards and the national minimum wage. So you need to, again, be looking at that and not just, rely on something you did 5 years ago to assess your award compliance. Be cognizant of the fact that those minimum entitlements increase generally each year. And so we're expected to see what the increase will be in the next month or so. I saw when I posted on LinkedIn, someone asked me about, do I have any views on what that increase will be? I think it'll probably be somewhere between the 2 and 3% mark. Jess, I don't know if you have a view on what you see. I think they'll take into account the fact that we'll also have another super increase this year, which is they took that into account last year. They'll obviously take into account the economic factors in terms of increased interest rates and cost of living and all of those things. So that's where I think it will kind of sit, but we'll wait and see. Obviously, most employee organisations are advocating for something more like 5 or 6%. And then the employer associations are kind of sitting around that 2 to 3% mark. So we'll see. Jess, did you have a view?
Well, I had just kind of read some, different articles and news around certain industries really advocating for that lower wage increase. The industries you would expect, like hospitality and tourism, and everybody who's not really had a thriving business over the past couple of years. And it's not probably with the context of not wanting to pay employees more, but so much as the wage increase on top of them trying to get their top line revenues kind of back. I think some of the industries that seem to advocate kind of that lower increase were really the ones that you would expect to have been most affected by COVID and being shut down in activity over the past couple of years.
Yeah, and we've seen also the Commission acknowledge that in terms of when they've implemented the wage increase, they've staggered some and kind of pushed back the increases for those industries that have been more affected by COVID. So it'll be interesting to see whether they do it again this year. I don't think they'll probably do it as much than they have in the last kind of 2 years in terms of staggering that increase, but we'll again wait and see in terms of what they decide. But yeah, I kind of think it's probably going to be around that 2-3% mark. So I'll hand over to you, Jess, in terms of considering if you're going to scope an award coverage or award entitlement.
Absolutely. So, I think Erin set this up pretty easily that, as the accounting firm, a client or a contact might reach out just with the context of, we're looking to see if you can help do a 6-year historical calculation of X number of employees covered under the clerk's award. But, can you give us a quote of fees? And within that there's a lot of scoping considerations to kind of iron out the true details, because ultimately the way that these reviews are conducted, you don't just have one calculation, you actually have a lot of sub calculations and then set off to consider that might be against different employee cohorts. And for clients who have actually, kind of undertaken the full efforts, they get that kind of as they dive into, it's not just one number that you're calculating, it's actually really ironing out, who's in scope, the employment types being full-time, part-time, casuals. They're going to have different award rules that actually apply, different entitlements that come into play as to when to acknowledge a shortfall in the set-off that's permissible. Periods of review. It might be requested on us that it's a 6-year review, but if there's deliberation that happens, and we've had this happen a lot, clients kind of go back and think about it for a couple more months. We kind of get into this, well, 3 months ago, the period would have been X, but now, 3 months have passed. So, where's the start and the end point? Just to reiterate that, the award coverage and classification is really important. As mentioned, Grant Thornton doesn't have an established legal arm, so we don't undertake anything that would be foreseen as legal interpretation. We kind of stick to the calculations. But whenever they say these many employees under the clerk's award, we're taking that under agreed upon procedures, that's already been diagnosed by somebody, and that award coverage is sufficient. If it turns out not to be, that's something that we'll state early on, that Grant Thornton's not assigning award coverage or testing award coverage or employee classifications of levels that you've assigned those roles within the coordinates of our review. Whether or not that there's been any previous reviews done, or if this is going to be the first, kind of deeper review that's undertaken by an organization, actually ends up being more important than you might think. And there's been a couple of instances where a contact put out a competitive tender across all the accounting firms and law firms alike. And actually, when they got back 7 responses, they said everybody seemed to give us something, way larger than life, way larger than what we felt we needed. We thought it was going to be a lot more straightforward. And they realized kind of within their, scoping brief, they didn't acknowledge that there had actually been a existing review performed, and what they were asking for is a secondary review, not somebody doing the first pass that needed to cover all of the bases, I suppose. So that's really important, just to be able to communicate either internal or other external firms that have done a review, and where you expect to have a secondary review done in accordance with those efforts. Any legal advice that's in progress, Erin's example of set off and contractual terms versus award annualized salary provisions, that ends up being really important. And we've been in engagements where there's legal considerations such as that going on in the background. And when we actually kind of get conclusions forecasted, we basically kind of have to rework efforts to incorporate that set off, versus if that was ironed out and communicated to us up front, we would know exactly how we need to basically set up our calculations for each cohort of employees, so that it actually kind of meets how we're going to set off payments made to employees. And that's something that's just us understanding what legal decisions might still be brewing in the background within the organization, and where instruction might change, from our approach. Anytime that you have known, previous issues or back payments that have been already made, it's just helpful to know, what other things have been coming to the surface, so that if we do our calculation and we say, hey, you missed a lot of certain allowances, you can kind of pair that up with maybe something you thought was previously rectified within your organization. Maybe you did the back payment, but the system actually didn't adjust how the allowances were getting triggered. We've seen that come across. So it's just helpful to understand previous issues, so that whenever we get to the findings stage, that seeing if that syncs up, or if we have any insights amongst issues that are already known to the organization. And then one of the last things I'll mention is that the recipients of findings, whether it's a schedule of underpayments or a final report, ends up being really important. From a Grant Thornton perspective, stakeholders could be, the report needs to be in findings need to be fed back to the board, but ultimately there's a lot that stays within the organization. But anytime that you're going to have a report kind of be evidence, I suppose, as to defending back payments, how calculations were done, going to the regulator, it's not uncommon that if you have your external financial auditors, might want to do a quick review of calculations that might feed into your overall financials. It's really important to kind of say, not only can you help us identify underpayments, but then also kind of the ongoing effects of, where the report might land longer term, gives us, is considered by us in the amount of detail. And actually, if it's going to go into administration, or has the chance of going into administration or any type of legal proceedings, then that's where we make sure that it's signed off by our forensics team and somebody who's kind of more qualified to take that into legal proceedings. But on the surface, I think understanding what data and information sources you do have available within the organization, whether or not you know that you have gaps in how time and attendance is recorded, or if rosters have been maintained, edited, adjusted for different changes in scheduling, and then just overarchingly your payroll data and the types of pay items that have been set up generally, on a per employee basis, because what is really important actually kind of comes down to, if you've got special agreements for toil and, in exchange for overtime, it becomes really important that we know how that toil payments might be processed, so that we can recognize them appropriately in whatever set off has been determined. And so having, that awareness of when undertaking the deeper dive, or even putting anything out to tender, what's something that might, one might spend extra time figuring out in the course of the engagement, and create additional efforts and work down the road. This is kind of just the overarching checklist of things to be aware of, and that you might want documented on your end before undertaking.
Yeah, and I think while it's very helpful, obviously, for organisations to be able to lean on that data to assist with calculations if you're doing it internally or if you're getting it done externally, I think the more data you can provide, the better, in terms of it will give you a much clearer picture of any gaps you've got. Whereas if you're just making a lot of assumptions, it's probably not great in terms of really understanding the risk that you've got. Whereas if you've got very clear data that you can rely on, like Jessica is talking about, in terms of overtime arrangements, time in lieu arrangements, specific arrangements you've got for particular employees, that's very helpful. And also, I just wanted to remind you that under the legislation, there is also obligations in respect of records and the records that an employer must keep. And one of the things is if an employee is entitled to payment of a penalty rate or loading for hours that they've worked, so the number of overtime hours or things like that, there's an obligation under the regulations for employers to keep records of that. So we need to understand the number of overtime hours worked each day and when they kind of started and finished those overtime hours. And that's a requirement even if we're choosing to use that contractual set off clause. So even though we're saying we're paying you $70,000 or $100,000 to compensate you for all your entitlements, from a record keeping perspective, technically under the regulations, it's a requirement for us to have these records available. And again, that's because, a Fair Work inspector might turn up on our doorstep and say, okay, you've got these employees, we've assessed them as covered by an award, you agree that they're covered by an award, you're paying them $100,000, how do you say that that's sufficient enough for their award entitlements? And if we've got nothing to show in terms of hours worked or things like that, it's very hard to prove to an inspector that we're paying employees sufficiently. So that could give rise to bigger issues in terms of you might get compliance notices and things like that, which I'll touch on in a second. But that's why it's very important, I think, for our records and the records that we're keeping to be very consistent, and we stay on top of those, because that's what we'll be relying on to say to an inspector or the Fair Work Ombudsman or an employee who might question us in terms of what they're getting paid, to say, well, here's our records of what we say you've worked, here's what you would get under the award, we're paying you $100,000, that's sufficient enough to compensate you for all of those entitlements. So your records are extremely, extremely important. And I think a good example of that, this is just a slide, again, just reiterating, if we're using that annualized wage arrangement under a modern award, what those records are that we need. So they are just a little bit different in terms of the annualized wage arrangement. As I said, very administratively heavy in terms of those requirements. And I think a good example of where it might go wrong in terms of annualised wage arrangements, which we probably all saw in the media, was George Columbaris. So you probably all remembered that was very heavily publicised in the media around underpayments by a number of the entities that he was involved in. And so that's hospitality industry, or they were covered by the restaurant industry award. And they relied on an annualised wage arrangement for a few of their employees, and they came unstuck in terms of the annualised wage they were paying. When you looked at the award entitlements, they weren't taking into consideration Saturday and Sunday overtime. They weren't taking into consideration, so there was a provision in that award that talked about a split shift allowance. So for example, if you came in the morning to prep for dinner and then you came back later, that was actually a split shift. And so there was an additional entitlement for that allowance that they weren't really taking into account when they were paying that annual wage. They also didn't keep records in respect of those arrangements in terms of the start and finish times of employees and things like that. So that's where they came unstuck for their annual salary employees, Sunday overtime I've mentioned. And so it's really around those kind of issues that Jessica and I have both touched on in terms of penalty rates for work outside your ordinary hours, your overtime considerations, and any allowances that might be applicable. So for example, if an employee, a lot of awards have that employees have to get at least a 10-hour break between working hours. And if they don't, then that second kind of work goes into overtime rather than normal rates. So it's things like that that might trip us up in terms of our annual salary employees. And obviously with George Columbaris, we kind of saw what could happen if we do get it wrong. And so this wasn't a case that went straight to, media attention and the Fair Work Ombudsman entering into an enforceable undertaking with them. They did actually get a letter of caution back in 2015, I think it was. I think a number of employees had reported to the Ombudsman that they thought there were some issues, and the Ombudsman wrote to them and said, we think you've got some issues here, can you have a look at this? They wrote back saying they would, and they didn't actually do that, which then led to bigger issues. And then they self-disclosed about $7 million, over $7 million in underpayments, and they entered into an enforceable undertaking with the Ombudsman, which means they didn't get prosecuted for their breaches, but they gave undertakings to do workplace training. They gave undertakings to have audits done in terms of their payroll processes. They had to make public announcements around their failures to pay properly, and they had to do that in certain newspapers. George Columbaris had to get up and speak at industry events about his underpayment and what he learned from that. So very specific provisions that the Fair Work Ombudsman required in terms of that enforceable undertaking that they were prepared to agree to. And they also had to make a $200,000 contrition payment, so basically a payment for their breaches, like a sorry payment basically, as well as obviously back paying all of those employees. So I'm not saying that it's going to go straight to kind of that realm of an issue. The Fair Work Ombudsman does have discretion in terms of what compliance they might seek, and they don't tend to go straight to litigation or enforceable undertakings. What will generally happen is if they come in and they kind of see that there might be some issues, they might issue you with what's called a compliance notice. And that's a notice basically saying, we've kind of identified some of these issues, we need you to fix them, and then you've got to prove that you've taken the steps to fix them. And if you do that and you comply with the compliance notice, then that's kind of the end of it. If you don't comply with the compliance notice, then that's when you might get to litigation and things like that, where they'll prosecute you. The types of cases that we see in courts, Fair Work Ombudsman is very strategic in terms of who they choose to prosecute. So they're not going to prosecute everyone. They tend to focus on industries or organisations that are going to have a big media coverage, but also industries where we see a lot of vulnerable workers. So restaurants, restaurant industry, hospitality, even agriculture, if we've got people, on farms picking fruit and things like that. If there's a repeated failure to cooperate with requests from the Ombudsman, so they kind of know you're a repeat offender, that's when they'll tend to litigate, and you've got that history of prior contraventions, and there's that deliberate non-compliance. So it's not like, oh, we didn't know, sorry, and we'll now take steps to fix it. It's like, yeah, we knew and we just did it anyway. Those are the types of situations where you'll tend to see them really go to that litigation path. Aside from that, they'll use what I've got on the screen there in terms of their other enforcement mechanisms, which aren't the kind of public forums enforceable undertakings are, but the compliance notice and infringement notice and contravention letter aren't. So they'll just be sent to you directly to say, so an infringement notice is specifically around record keeping obligations and payslip obligations. So if you're not recording on your payslip correctly, or you haven't kept records, you'll get an infringement notice generally. A compliance notice is if you haven't complied with the term of the award or something like an annualized salary provision, they'll generally issue a compliance notice. They might come out and assess everything's fine, and then they'll issue an assessment letter saying, we've assessed you and you're great. And you think, oh, wow, I'm really glad I attended that webinar with Jessica and Erin, because that's why I got the tick of approval. So again, it's really I just wanted to touch on what the end results might be, and I don't want you to be scared that you're all going to end up in litigation. I think really the message we wanted to be sending was, if you get on top of it in the first place and you have your records in place and you kind of know how we have to comply from an annual salary point of view, then we shouldn't have issues in respect of the Fair Work Ombudsman turning up and telling us we're doing it all wrong. And so just to kind of recap, I think, first of all, we need to just establish whether we have award coverage, and then the classifications, and then do that assessment using a tool like Jessica's or something we've got internally to make assumptions and get kind of a base level assessment. And I would do that kind of each year around when the annual salaries wages increase under awards and the national minimum wage, just to make sure we're compliant, and then staying on top of those obligations. Jessica, did you have any final things you wanted to mention?
Yeah, no, I think I just thank everybody for the time today, and hopefully, painting a picture of, what to expect from an accountant and services provided versus, legal firms. And on these topics, we only see more and more collaboration. Having done several of these and sat into mediation with the Ombudsman, we try to kind of bring those points to the surface of learnings and, what has trapped up, I suppose, our client from one thing to the next, but it doesn't need to be a one size fits all. It was really interesting to me sitting in with the Ombudsman, where they had 7 attendees, and hearing them query a lot about rest times. And although that's not in, you have to connect the dots, because we know exactly how we tested different rest patterns or consecutive days on versus consecutive days of rest sort of thing. But those are the types of details, they kind of squeeze out in those discussions, because it does link back to overtime. They're really in favor of the employees, as you would expect, wanting to make sure that the employer is cognizant of sufficient rest times, and if they're not, they're paying the employees for those types of premiums that might attach to either rest per shift or rest per a roster cycle, that sort of thing. And so, all those takeaways, I suppose, we raise to the surface, which sometimes does involve legal involvement to actually kind of make the firm conclusion, but it's all coming from a great place of helping everybody be compliant, giving you a scope that's fit for purpose, and one that you have more confidence in saying that the right approach was taken and the right people are involved at the right times. So I want to thank everybody and Erin and Vincent Young for inviting me here today, but hopefully everybody learned something and you're happy to attend.
Yeah, thanks, Jess. I really think some valuable insight into kind of where we start in terms of assessing annual salaries and some tools that we might have available to us. And I agree with you that obviously the Ombudsman's very pro-employee and protecting employee entitlement. So they will press you on certain things that they know the kind of employers trip up on. And when I was talking about record keeping obligations, if we don't have the records as an organisation, but the employee has kept a diary or a logbook, then the Ombudsman will accept that as the true record of what they worked. So again, it's really important that our records are complete and that we do stay on top of those records. Okay, so I think that's it for this afternoon. I can't see any questions in the chat. So unless anyone had any questions, we'll sign off for the afternoon. I hope you all enjoy the rest of your afternoon. Thanks for joining. We will send out the slides, and if you would like a copy of the recording, please email me and I can send you a copy of the recording as well. Enjoy the rest of your afternoon.
Thanks, Erin.
Oh, we've got one. Oh, Julianne's just saying thank you. Thanks, everyone. Enjoy.